All right, who's here on J. David Taylor?
I'm here, Your Honor. Ready?
All right, Mr. Taylor, if you'll come down.
My client is one of Louisiana's favorite sons.
Oh, that's a bold opener from the defense, trying to humanize Taylor right out the gate. But here's the thing. In criminal court, charm only goes so far. Do you think the judge buys this kind of soft sell, or does it fall flat?
Hey, everybody's
Okay.
favorite song. Probation, this is an application.
It's agreed to deferred. Okay.
Court is calling 2025 CR 008182, State versus J. David Taylor. Could I have parties announced?
Lauren Espinosa for the state of Texas.
James Seeloff for the defense.
And are you Mr. Taylor?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, I have.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Taylor, did you review the application for deferred adjudication with your attorney?
Yes, you know the difference.
Yes.
This is the document that says that you want court to consider you placing you on community supervision or probation.
Right.
Did you review that with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment that tells what you're charged with?
Yes, ma'am.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, we waive.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Taylor, did you review the admonishments that tells you what you're charged with, what your plea bargain agreement is, and what rights you have? Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And there it is, straight to the stakes. This isn't shoplifting. Robbery automatically escalates things because of that element of force or threat of force. The difference between petty theft and robbery could literally be decades behind bars. Wild, right?
You're charged with the offense of robbery. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in the prison? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I believe he is.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
This is a critical safeguard. The court has to make sure a plea is voluntary. If Taylor later tried to claim, "I was pressured," this moment right here would shut that down. Everything on record, everything locked in.
Ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, thoroughly.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine. State recommends deferred adjudication. They'll take in consideration 2025 CR 008183, and there's to be restitution, if any, to the Dollar General store. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
That's our plea, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, no contact with the Dollar General and with Erica Aguilar. Did you understand that to be recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State offers what has been marked as State's Exhibit 1 in all attachments.
No objection, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state would be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, we are, and we waive PSI.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor, the item that was taken in the store was returned to the store. So as far as restitution, there is none. And there's a TIC of the evading arrest, Your Honor, as part of the plea bargain. And I just got the motion for dismissal. My client, whereas he is homeless at the current time, he does have employment opportunity through the nursing industry. Is that correct?
Oh, I don't allow that. While you're on deferred.
Whoa, the judge just cut that off fast. No health care, no working with vulnerable people. Makes sense though when you're on felony probation. Courts want zero risk of new allegations, especially in jobs involving trust. Did you? Notice how quickly she drew that line.
While you're on probation and felony probation in this court, I don't allow people to work as home health care providers,
Healthcare.
minors,
It's
nursing.
triage for like a call center.
When you say triage for a call center, what do you mean?
It's like people would call in from various companies, and then we do the triage before they are transferred to nurses.
So,
On the phone?
Right.
what is, I've never heard of
Like,
triage on the phone. What are you, a 911?
Right. Somebody would call in, like they have a medical emergency, and then we kind of type up whatever the issue is and transfer either to.
All right, who's allowing you to do that?
It's a job opportunity that I have. I've worked at CareNet before, so it's still an open opportunity to go back.
Well, why are you homeless?
I went through an eviction process after the death of my father, and kind of just hard financial times.
He's one credit away from associate degree, is that correct? Through SAC and Northwest Vista. That's how much education he has.
Okay.
And that's why we're pleading for, or wanting deferred adjudication in this case, because he's got that opportunity, and even at his age, he may consider the armed services, and they will not allow it.
Well, how old are you?
36 currently.
And you told me Marine Corps will take you up to 40?
So
Well, why wasn't this done before all of this happened?
just mostly, I was trying to obtain my documents after the eviction. I lost like a lot of my paperwork and most of my home, so it's been a very difficult couple of years rehabilitating.
All right, is there any drug issues with you?
No,
Do you have any children?
no.
All right, this is what the court is going to.
Big moment deferred adjudication is basically a second chance. If Taylor follows the rules, there's no conviction on his record. But mess up once? Boom up to 20 years. It's like walking a tightrope over a canyon.
Going to do? Court is going to sentence you to 4 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the Dollar General stores, although my understanding they no longer have anything that costs $1. There's to be no contact with Erica Aguilar, that's Erica with a K. 200 hours of community service restitution. And I'm going to order the theft course. Once he completes the theft course, the community service hours will be deemed satisfied. There's to be field visits 1 time per month for 4 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just understanding that I do apologize for.
No, I want you to understand what's going on.
I do understand, but I want to just apologize. I guess I was kind of just in a desperate position, but the time I spent at Bear County, these 4 months, I gained a clear mind. So I realized it's not a appropriate course of action and that there's other alternatives.
Yes, and here's the thing. I understand when people go through different things, but we do have laws, right? And I understand that the item that you stole, was...
This is where the courtroom reality check hits. People think it's just wipes. It's only $10, but nope, Texas law doesn't care about the price tag, only the force used. That's how a bottle of Clorox wipes nearly put this man in prison for 20 years. Think about that.
Clorox wipes. But when you take an item and then you make physical contact with someone and you're taking that item without permission, that's when it becomes a robbery. And you're looking at 2 to 20 years. And a lot of times people will look at it and they will just say, oh, it's only $10. Oh, it's only $5. That's the range of punishment for robbery. And in the penal code, that's what a robbery is. You understand?
Yes, ma'am.
I represented someone before and they were on parole. And they were on parole during a life sentence. I didn't represent them, for their trial court matter. I was just representing them for their parole. And you know what they were doing a life sentence for? Stealing, the little metal piece that you have on a water hose that you screw in to the faucet. That's what.
Let that sink in. Life in prison over a $2 part is not the item. It's the law and the history of priors. This is why judges hammer defendants so hard about making better choices. One small mistake can stack up into a lifetime sentence.
They stole. What is that, $2? And they're doing a life sentence. Yes. So you got to make better decisions. Otherwise, you're going to be looking at yourself, maybe being a repeater or a habitual. The fact that we're homeless, the fact that things haven't gone our way, doesn't give us an excuse to steal. You understand?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And just like that, it's done. Taylor walks away with probation instead of prison. But the judge made one thing crystal clear. This was his warning shot. What do you think, Will? He make the most of this second chance, or is this just a pause before another downfall? Drop your thoughts below.
All right. Good luck to you in this court. In order to be successful, communication is key. If there are issues, you need to let your probation officer know about it. If you feel that they're not addressing it, you can always approach the court. Do you understand?
Yes, ma'am.
All right. Good luck to you. Probation will go over conditions with you.
Thank you. God bless.
Oh, God bless you too.
Evading arrest was dismissed.
Yes.
Thank you.